within 2 years of that day one? What if they didn't find out that they had the possibility of a claim for 3 years because they don't have access to your system? They're kind of in the dark about certain things and they didn't realize until later. Well, if they didn't find out about the claim until 3 years in, they would still have 2 years remaining until that 5-year mark to bring a claim. What if they didn't find out about a claim or didn't figure out that they might have a claim until year 4? Well, because of the FCRA statute of limitations in that situation, they'd only have 1 year to file a claim because 5 years is the max. So historically, background screening companies have said, we want to keep background screening reports and backup data for the maximum amount of time that we could potentially be sued under the FCRA. That, man, if we're sued, we want to make sure that we have the proof that we need to hopefully win the case. So that is what has guided the industry historically. Is that conventional wisdom wrong? Well, maybe. I think that the question that a lot of us are bringing up now is that really the most strategic approach to keep it that 5-year period that people historically did? Or does it make sense, given the changing litigation landscape, to keep it for perhaps a shorter period of time? And so what we're certainly working to do as a law firm, working with a lot of the background screening companies in this area, and I'm sure a lot of other law firms are trying to do so as well, is to try to help background screening companies strike the right balance, right? Try not to keep it too long, try not to keep it too short. And what we're going to talk about next is what is the push and pull there? What are the factors that might cause us to keep it a little bit longer? What are the factors that might cause us to keep it a little bit shorter? And then we'll talk about how to resolve that, how to come up with the right balance for you. So what are the factors favoring a shorter retention time frame? Well, Barton began to allude to this at the beginning of the presentation today. There are 4 things you'll see on your screen right now that, at least in my perspective, are the biggest reasons causing us to rethink whether people should be keeping it that 5-year period or whether they should keep it a shorter period of time. Each of these 4 factors suggest that a shorter period of time might be a wiser course. What's the first factor? First one is class actions. You know, class actions, you go to any of the NAPBS conferences or the other conferences in the background screening space, there's probably no 2 words that you hear more often than class actions, right? Class actions is kind of the boogeyman in the background screening industry. You know, for most CRAs that I work with and for most CRAs that I know, the prospect of a class action is the most concerning possibility that they face. Because it's one thing to be dealing with a single plaintiff case where there could be a settlement of $40,000 or $50,000 or $100,000. It's another thing to be looking at the types of settlements or jury or judge awards that we see in class actions, where it's not unusual to see well into the 6 figures, the 7 figures, and occasionally the 8 figures, right? Well, one thing that's important to keep in mind is that the resolution of class actions is typically driven by the size of the class. So if you were to survey the litigation out there, what you would notice is probably the biggest determinant of the big settlements is the big class size, right? There's a huge difference between a class action that involves 100 people or 200 people and one that involves 20,000 people or 50,000 people. Once you start getting up into those high numbers, the resolution of those cases goes up in a commensurate way. You know, it's often those ones that have 1,000, 10,000, 25, 50,000 people that it's often those cases that result in the biggest class action settlements and awards. One of the things to keep in mind is how the size of the class is determined. The scope of the class is usually determined with a background screening company's records, right? So imagine a plaintiff comes up with the allegation that the background screening company is facilitating some sort of improper written consent process, and they want to bring a class action on that basis. Well, the plaintiff's attorney is going to know that one individual or 2 individuals that they're working with to first launch the lawsuit. But they're not going to know all the other people that went through that background screening consent process. And so usually there's a period of time in the lawsuit called class discovery, where plaintiffs' attorneys find out who those potential class members are. And the way they often find out who those class members are is to gain access to the background screening company's records and to go through those records and identify people that are in the exact same position as the named plaintiffs. One thing to keep in mind from a data retention perspective is that the shorter retention cycle that you have, the harder it will be for them to identify class members, right? Because let's say you get rid of information after 6 months or after a year or after a year and a half. Then if it's completely gotten rid of, they won't be able to identify class members that are 2 years and 3 years and 4 years out, right? That information simply doesn't exist. So one of the things that's motivating people to rethink the retention time frame is that idea of limiting the discovery into potential class members and limiting the identification of those class members so that you can keep class actions hopefully smaller. A second thing that's really driving people to rethink data retention are these free file requests. Now I know from talking to a lot of you that some of you get a bunch of these, some of you don't get very many at all. What we're seeing across the landscape is that plaintiffs' attorneys are increasingly making free file requests, and those are essentially requests to go behind the curtain of the background screening company and get everything you have related to a particular consumer. And the idea that the plaintiffs' attorneys have is it gives them an opportunity to see whether you did something wrong or that they believe you did something wrong so that they can identify those named parties for potential class actions. The sooner you get rid of data or the more data that is eliminated, the less information you will have to turn over to plaintiffs' attorneys, right? So the less scrutiny plaintiffs' attorneys will be able to give to the data that is related to you. The other reason in the free file space that it can be helpful to get rid of data sooner is because free file requests take some time and take some expense to respond to. We work with clients all the time on free file issues, and inevitably there is time and expense that goes along with it, often more than people think on first blush. If the data is no longer there, it makes the free file response a whole lot easier. There's simply a lot less to give to the consumer or the plaintiff's attorney. A third reason that people are rethinking data retention and that 5-year historical norm comes back to how soon a lawsuit is typically filed. You know, generally, a single plaintiff lawsuit is going to be filed against a background screening company within the first year or so. You know, typically you have an unhappy consumer, maybe they filed a dispute, things didn't come out the way that they wanted, and usually within a few months after that, if a lawsuit is to be filed, it will be filed. Occasionally, we see lawsuits filed in that second year, but not very often. What we don't see very often are lawsuits, at least in the single plaintiff area, filed 3 or 4 or 5 years out. So one thing that's motivating people to rethink data retention is, well, if the biggest concern is proof, and if most lawsuits are filed in the first year, then maybe it doesn't make sense to keep things for year 3 and 4 and 5. Another reason that is driving a rethinking in this area is privacy concerns. You know, as you know, background screening information can be sensitive. All sorts of social security numbers that you all maintain, other private identifiers that you all maintain. And although, you know, certainly everyone does everything possible to try to prevent data breaches in this space, and I know everyone works very hard at that. The reality is that the longer you keep sensitive pieces of information, the more exposure that there is. So even if the chance of a data breach or a hack is remote, and I hope it is, and it generally is, there's still that chance. And so the fewer social security numbers and other sensitive pieces that you have on hand, the better protected that you are. So those are some of the factors that favor a shorter retention time frame. What about on the opposite side of the spectrum? What about the longer retention time frame? Well, many of you probably have contracts with your clients that say you will retain background screening reports or information for a specific period of time. Sometimes I'll see it 1 year, 3 years, 5 years, 7 years. I see all different things that background screening companies put in their contract. Well, once you've had it in the contract and the client signs that contract, that's binding, right? So unless there's a change to the contract, the expectation is that you will keep the information for that period of time. Now, some of you will tell me that, well, you may not have a client contract that says you'll keep it for a period of time, but you know full well that your end users, whether it's employers or landlords or whoever, that they expect you to keep the information, that they're not keeping the information very well on their end, and they believe or hope or expect that if ever there's a problem related to the background screening report, they'll be able to come back to you and get the necessary information. That may be a second reason to keep it for a little bit longer period of time, if that's what your client's expectations likely are. A third reason is the applicable state laws. As I mentioned, New York and California, when those laws apply, they have a more specific period of time that you're supposed to keep it for at least. The most meaningful one for sure is California, requiring you to keep it for at least that 2 years. You all know from being around in the industry that we don't mess around with California, right? California is our scariest litigation prospect. It's where we see the bulk of the lawsuits, or at least I'd say most often we see a lawsuit, and it's also where we see often the largest damages. And so we don't mess around with California. And so California says 2 years, and so certainly where California law would apply to a report or information, most CRAs are going to want to keep it for that, at least that period of time. The fourth reason that CRAs sometimes want to keep it longer is that proof reason, right? Once you get rid of the records, if they're truly gone, then you may not be in position to prove that you handled things the right way, right? Think about a reasonable procedures case, right? Someone says that you inaccurately reported certain information. Remember that the law does not require you in that space to make sure that every piece of information in your report is 100% accurate, right? It's not a strict liability statute. You're allowed to make mistakes so long as you have reasonable procedures to ensure the maximum possible accuracy. I'm sure you're all familiar with that language. Well, part of the way that background screening companies show reasonable procedures is to show what information was generated and what the trail of information was leading from, say, the courthouse or a private database provider all the way through inclusion into the report and the turning over of the report to the client. If information is available, that can help CRAs to show that they had reasonable procedures. Whereas if the information is gone, then they may not be able to show that they had those reasonable procedures in place, or it might be a little bit harder to show that the reasonable procedures in place. So those are examples of reasons why people might want to keep it a little bit longer. So how do you decide? I've given you reasons so far to keep it shorter, to keep it longer. Part of you may, some of you may be saying, well, that sounds like a typical lawyer answer. On the one hand, this, on the other hand, this. We're left to make a difficult decision in between. And the reality is you do have to make a strategic decision in between. But what we've put on your screen right now to consider are some of the factors that you might want to weigh, along with how we think most CRAs will tend to come down in this area. As you evaluate, or as the CRA evaluates how long to keep background screening reports and information, it's worthwhile to evaluate where you think your litigation risk is biggest. Some of you, particularly the bigger CRAs and the medium CRAs, you may line up with that view that class action risk is your scariest risk, and that's what you really want to guard against, right? Until that factor will weigh in favor of a shorter retention cycle. Whereas others of you, the smaller ones, the small medium ones, even some of the medium ones, you may say, listen, we don't see class action litigation, and we don't think it's likely we're going to see class action litigation. Our biggest concern is single plaintiff litigation. So if our concern is single plaintiff litigation, then maybe we want to keep things a little bit longer. You may want to think about what types of lawsuits you've seen in the past. How many free file requests do you receive? Are you concerned about a boatload of those such that it makes sense to get rid of information sooner? Or do you really not receive free file requests, in which case that's less of a concern? What does your client contract say? Does it say you're going to keep information for 3, 5, 7 years for the client such that they're relying on it? Or are you silent on that issue? Or do you say explicitly you don't promise to keep information for any period of time? Let's say your client contract does make an explicit promise. Are you willing to consider some sort of contractual addendum where you convince, get the client to agree that you don't have to keep it for as long as you originally talked about. You know, some of my clients are going that direction. How many of your reports are subject to California and New York law? Certainly if you have lots of reports subject to those laws, you're at least going to want to factor in those 1- and 2-year retention cycles. If you really never touch California or New York, then those are obviously less pressing concerns. I would say for most CRAs, retaining for 2 years will make a lot of sense. Why? Well, in 2 years, you're most likely to see most single plaintiff lawsuits. 2 years also gets you past both the explicit New York and the explicit California requirements. In 2 years, you're not keeping it so long that class action plaintiffs' attorneys are going to be able to go back for ever and ever to generate large classes, you know, like classes over the course of 5 years. They're going to be limited to 2. That seems like a reasonable balance. 2 years also limits free file responses, so that yes, you'll have to do some, but you won't have to do them forever and ever and ever. So I'd say for a lot of CRAs that I deal with, 2 years makes a lot of sense. But that doesn't mean that 2 years is the right answer for everyone. It's going to come down to the types of factors you see on your screen and the ones that we talked about earlier in this presentation. There may be reasons to go shorter than 2 years. There may be reasons to go longer, and it's worth thinking that through strategically. One last issue, and then we'll turn it over for questions, and I know TazWorks has additional things that they want to cover with you. One thing that I think is so important to keep in mind is, what does deleted really mean, right? Deleted electronically does not always mean it's 100% gone. You know, sometimes it can be recovered on backup drives, or sometimes there's a special storage area for deleted messages or communications or reports or whatever, right? If the goal is to make sure that information is gone such that you have potentially lower class action concerns or free file concerns, et cetera, social security number concerns, all the things we talked about earlier. If those goals are meaningful to you, it's worth thinking through whether deletion really means deletion. Because if it's not truly gone, if it's just on backup drives, then it can still be found in the context of litigation. It just can be a lot more expensive to get there. And what I tend to find in lawsuits is that judges typically split the costs of those more expensive checks or searches between the plaintiff's counsel and the defense counsel, right? And what that can mean is you end up paying a whole lot more money to recover data that you thought was truly gone but wasn't actually truly gone. So one thing, you know, I always recommend to people to think through is, if you're going to delete it, can you delete it fully? And the other thing I would mention in closing is about the difference between reports and backup data. You know, sometimes I see situations where the reports are gone, but the backup data is there. Or the backup data is gone, but the reports are still there. In my view, they work in tandem. Either you want the full palette of proof available to you for those reasonable procedures cases and other background screening cases, or you want it all to be gone. Having reports without the backup data can be problematic. Likewise, having the backup data without the reports can be problematic. So from my perspective, it makes sense to address both in tandem. Thank you for taking some time out of your day to listen. I'd love to hear what questions you have, and I know TazWorks has additional things that they'd like to share with you.
Yeah, thank you, Scott. So if you have any additional questions, you can go ahead and chat those in right now, or please feel free, if something does come to mind, to continue to use that link that we had provided earlier that I went over, because we will continue to monitor those as well and get back to you. So we'll wait a minute here and see if we get any additional ones on the chat. Otherwise, I believe most of the ones that came in, Scott did address throughout his presentation. All right, so, all right. Oh yeah, Scott, you know what? Are you going to be able to get a copy of the slides out, or how would you like to handle that?
Yeah, I'm happy to share the slides with anyone who's interested. So Either I'm happy to provide them through TazWorks, and TazWorks can send them out, or if you want to email me at the email address you see on the screen, I'm happy to email you directly.
We'll make those slides available at the time that we make the recording available to everyone. That'll probably be early next week-ish. We'll post it in software news on our blog and on YouTube.
Okay, so we had a couple additional questions come in. So Scott, one of the ones is, what's the CRA's responsibility after a contract is over as far as keeping the reports on file?
So good question. What's the responsibility after the contract is over? Well, generally the rule is once the contract is over, the contract is over, and in general, parties no longer have obligations. But you will see, if you look at contracts from time to time, that there will be a provision that's called a survival clause, which makes clear that even when the contract is partially over or no services are performed any longer, there still can be obligations to continue certain things even after that point. So it's important to have full knowledge of the contract and what the obligations are, and make sure that that termination of the contract truly means termination of all the provisions.
Okay, and we had another question come in, and somebody wants to know how common are these lawsuits?
Well, if you're talking about background screening lawsuits generally, they're very common. We have seen a huge uptick in background screening lawsuits over the last 5 years in particular. There's all sorts of commentary out there about how background screening lawsuits have increased. They've become arguably the new wage an hour, that they're a central focus of the plaintiff's bar in a way that they weren't before. So if it's just a general question about background screening lawsuits, I would say that that they are increasingly common.
Yes, and I would agree with you on that. So the other question that we had come in, somebody references a particular state, but I think maybe if you just have some general thoughts, when certain states require that background checks get renewed every X number of years, in this case the specific question says 5, how do you recommend, or what might be some general guidelines in terms of handling those types of requirements?
Well, I think a few different things. One is that rather than considering a subsequent report a renewal, I would generally be inclined to consider it a new report. So there would be a data retention cycle that applies to one report in the backup data, and then there would be a new cycle that applies to the new background screening report, or the second background screening report, as well as the associated data.
Scott, I have a question for you. This is Barton.
Hi, Barton.
What is I believe in California there's a requirement that you keep the reports for 2 years, but you have to keep the name of the person who inquired for another year additional. Is that true?
No, I don't recall that off the top of my head, Barton. I'd be happy to look into it, but I'm not aware of that off the top of my head.
I'll send you a link.
Sounds good.
All right, so the rest of the questions that we had come in, we will try to get through those. And like I said, please feel free to keep sending those in off of the links that we had provided earlier for the webinar. With that, again, I want to thank you, Scott, for your time. And that's going to wrap up the first part of the webinar. And now we're going to move on to the second part to discuss retention options in the system. So I'm going to turn things over to Kayla, Adam, and Barton.
Hello.
Hi, everyone. 1 second, I'm just going to pull up the right window and make sure that we get everything up. So hold on 1 second while I get this going correctly. Okay. Can you guys all see a window? You should see a copy of the email that you received today. And I'm going to, before we dive into the specific questions that we've gotten from people, I'm going to just review a few of the resources that we have available to you. because I'm going to reference those several times as we talk about these different questions, and want to make sure that you guys have the materials to be able to go back, review the information more in depth as we go through or after the fact. So in the email that you got, you should have seen there's some links here to some articles and materials we've created. Those are also in Software News. So if you go into Software News, then you'll see that there's the data retention webinar today. And, sorry. And when you look at that, it's got those links there as well. So if you lose the email, then it's okay. You can scroll back in Software News. So we have some links there that are available. And I'm going to review a couple of those. Barton at the beginning of this gave a little bit of an overview, but we do have a link here that goes over our policies, kind of giving some examples of different ways they will be able to be configured once we have everything rolled out, and kind of what all the different settings and kind of stages are. We've created an article on our blog. It is linked in all of those places, and from the other article that describes like the different phases of the rollout and what will happen, what will change at each stage, what you guys will need to do. We've got an article specifically about how to configure all of your data retention settings that will become available in step 1. And so going into kind of the more nitty-gritty of what exactly settings we're going to be making available to you. And then from that, there are a couple other links for accessing the archive, decrypt files, that kind of stuff. So I'm going to jump into some of the questions that we got and not spend a huge amount of time giving the overview. Barton gave a really quick one at the beginning of this discussion, and because you guys have access to all of that stuff already. So to begin, oops, one second. To begin, I am going to show you guys, I've got a question asking about Pennsylvania and the 5-year time frame. I'll address some of that in terms of making sure that those are 2 separate reports and each one would expire after 5 years. It's not a renewal where it continues. The other part of that, something that we have changed in our way that we are doing this based on feedback and talking to all of you guys. We gave this to you guys really far in advance so that we can get feedback from you, is that the TazWorks data retention timeframe is something that can be set by CRAs. Originally we had it 1 to 4 years. We've now extended that to be 1 to 5 years. So that gives you guys a little bit more flexibility that if you want to keep all the data within the TazWorks system for up to 5 years, you can do that. That'll make it easier for reordering some of those searches, those kinds of things, and hopefully prevent any of the major issues that you guys saw with that, as well as just giving you a little bit more flexibility in general for whatever reasons you want to hold your data. So when the settings for purging become available, that will be something that you guys will be able to set. Those settings are not going to actually become available for quite a while. If you look at this article about data retention settings right now, the settings that are available are just related to archiving. And that is because we are rolling this out in several stages. So the first phase is just giving you the settings for archiving. Phase 2 will just be the archiving, and then phase 3 is when we will give you those settings for the actual retention or purging timeframes. And we'll have a pretty big gap between when that becomes available and to make sure that you guys are really comfortable with all the archiving stuff, don't have any concerns first, and then similar to phase 1, those settings will not do anything for quite a while, and we'll make sure that you just have the settings, you're able to get everything configured, get questions answered, and then we'll make it active. So you should have 5 years, and one of our questions, was related to how, when you will be able to set those timeframes, depending on which time frame you're thinking about. If it is the archiving time frame, then that's something you'll be able to set in probably a few weeks. as we get closer to doing that, rolling that out, those settings won't do anything immediately, and then slowly we will make those settings effective and give you guys warning of that. And then the setting for purging will become available much later as we make sure that everyone's okay with it and work with you guys throughout this process. So, all right, so I'm getting some questions that are coming in the chat. I'm going to keep going through some of the pre-submitted questions and cover those, and then I'll come through and respond to those questions that are in the chat as well, if those haven't already been covered. So just so you guys know, I'm seeing those, and we'll get to them. So the next thing asked, if we want to just use the default standard settings, we don't want to store any data significantly longer than what TazWorks already offers. Do we need to do anything? And the answer is no. By default, we're going to set everyone to the maximum time frame available for both archiving, purging, anything available. And so you won't have to do anything. You won't have to set up archive access. You won't have to set up encryption keys. You won't have to do anything at all. That'll automatically be done for you. And if you don't want to keep data past the 5-year time frame, nothing needs to be done. If you want to keep it shorter than the 5-year time frame, then you can go in and it's just a single setting that would be available to change that time frame down from 1 to 3 or 4 years. So that part, you don't need to do anything else. Right now, what's being displayed on the screen is in our blog. And so that's on our marketing site. These other articles are available in our support knowledge base. All of these are linked in software news right now and in the emails that you should have received. So you don't need to do anything if you don't care about exporting data and saving longer than that. So another question we got, will all data retention timeframes be able to be configured on a client or a CRA basis? And I believe that's one that we got in the chat as well. The overall time frame is set on the CRA level. So we will have the ability for you to be able to set that 1 to 5 year time frame is on the CRA level in terms of when it's purging. However, you can set on the client basis at what time frame you would like those things to, which clients you would like to export their data to be saved externally. So if you have 2 clients that you need to save their data forever because you've got it in their contract with them, or they have a requirement where they have to keep their background reports for the entire employment term of that employee, then you can do that and you can save all of those things for them while not saving it for all of your other clients. And so you've got a mix of both settings where most of the stuff is going to be at the CRA level in terms of the overall time frame, but then you can customize it to save things longer for different clients. So another question asked about litigation hold. There is the ability to set a litigation hold, and so if you go to the article about the settings, then you can see a preview of what it's going to look like, and there's an archive reports after date, the reminder email, and then there's postpone archiving due to legal hold. And you can check that box. That will mean that reports are not locked, they are not exported to the external server. If you have that set up, they are not purged, nothing will change. It will just freeze any of that from happening. And so that way you can make sure that there are no issues if you are dealing with litigation. And we will send you a reminder email once a month that your account is on a litigation hold, just to make sure that you're aware of that, so that once you no longer need that, then you can turn that off. And that way you aren't accidentally keeping data much longer than you would plan on doing that. So next one, how will the archiving of authorization documents be handled? So each attachment to a report will be converted into a PDF and stored with the report. So for each report, if you externally archive and export all of those documents for a client, then there will be a folder for that report, and it will create one PDF that is just for the report, basically as it was delivered to the client. And then there will be one that is for all your internal notes, so that you've got a record of those, but it's not attached to the report if you need to give that to the client. And then each other attachment or disclosure, authorization form, etc., for that report will also be converted into a separate PDF. And so you'll have a folder with everything related to that report. Each of those will be encrypted to make sure everything is as safe as possible. You can bulk decrypt things as needed, and you can download and store those as you desire. If you don't have exporting set up, if you've decided that you just want the 5-year time frame or 3-year time frame or whatever, and you don't want to store data longer than that, then everything will stay in the system exactly as normal. But then it would just disappear from the system, and there wouldn't be anything anywhere else. So that's about that part. I'm going to jump into a couple questions that are here in the chat, and then jump back to some more that were pre-submitted, just because some of these are follow-up questions. So one of the questions said, I'm still not clear on what it means to archive and why are we getting email for such. So the archiving means there are two different things that happen. When something is archived, then that means that it is locked from being able to be edited by the CRA any further in terms of the results. You can still do some administrative things like being able to add charges or that kind of thing, but you can't edit any search results, any of that kind of stuff. It's locked from further editing. And then if you have it set at that same time to export a file to the CRA's or to the client's external archive, then it will create those PDFs at the same time. And so what it does is it creates an external, we've got an Amazon server that is set up. It'll create an external server just for you guys where you can access all the reports that have been exported. Like I said, each one will be in a separate file. All of those will be under a folder for each client, and you'll be able to view those and see what is stored longer than that. Everything when you export is saved in both systems for the duration until that purge date. And so if you have your purge date set at 5 years, then everything's going to stay in TazWorks for that whole time and in the external for that time. And then after that 5-year time frame, it will be deleted from everywhere within the TazWorks system. So the archive reminder email is to help you remember to go and download those files from the external archive and save them to wherever you want to save them for a more long-term time frame, whether that's the clients to save themselves or whether you're setting up a place that you are going to store them yourself. Will we be able to set the 1 to 5 years per client? We've addressed that one. You will not be able to do it on a per client basis. That's on CRA, but you will be able to decide which clients you store for longer than that and export. All right. So the legal hold is a CRA status and a client status. That is correct, often because it's something the CRA is being sued as a whole, and as Scott mentioned, they file documents for everything. It's not just for that one client often. So that is a CRA-wide setting, not a client setting. Each time a user accesses a completed report is dynamically generated from the XML results. You just say MVR is mandating a 90-day period. That's the question about. I'm not sure which question they're referring to, but I think I've answered the ones above. So if I missed that, we can come back to that one. So you mentioned if a contract requires to keep information for the length of employment that that would be longer than 5 years. How do we create that setting for indefinite forever? So within TazWorks, you cannot save records forever anymore once this feature is completely rolled out. And we will be doing this very slowly, giving you guys lots of warning, but that's why we're setting up the specific external archive where you can set it up on a client basis. So on the same article, as you scroll down, there's a setting, about setting client export preferences. There's under each client, there'll just be a checkbox say, save this client's reports into the external archive. And when you check that, and you've set up your external archive access up here, and using some of these other links that are connected here, then we will export all of that. It will be saved in those encrypted PDF formats, and then you can download and save those wherever you want yourselves or deliver them to the client. But we, within the TazWorks system, will not be saving them for everyone. So, all right, I'm going to jump back into some of the questions that were asked previously and go through more of those, and I'll keep jumping back and forth. How will end users or the CRA be able to download reports scheduled to be purged from InstaScreen? So after you get things that are downloaded there, you've set or exported to there, you've set up these settings, you may have an archive reminder email that will tell you once a month, by the way, you've got reports, you might want to go download them. Then if you click this link here about accessing the external archive, we've got a whole article about how to set up your archive access really in depth and make sure that you're able to do that, as well as how to decrypt archive files. So we are delivering these files. They're in an external Amazon server, so they're really secure. They're in an FTP server is what it's called, which makes it possible for us to deliver large amounts of files very securely. And you guys will be able to download them there, and then you can do whatever you want with those files. I'm not going to go super in depth to this since it won't apply to everyone, but you can read through those articles. If you have more questions, then you can reach out to us. We will also, in between, once we get archiving working and before we move forward to anything else, we'll do more trainings and webinars to make sure that everyone completely understands how to do this. It's really smooth. We're not going to move forward to purging anything until we know that people can access their files, they can download them, there's no confusion, no worries with any of that. So that's how we're doing that. And if you have your data retention settings set to 2 years or more, and Scott said that the 2 years was kind of like a good time frame that will be work for a lot of CRAs, then that is something that really you only have to do about once a year. We've got the reminder emails that you can use like once a month, but as long as you're going in once a year, then those files are going to be in that server and you'll be able to download them whenever you need. So another question, there are two similar questions about transparency for the client and how long the reports are going to be in the system, when they will be purged, that kind of stuff. We don't have anything currently planned with that, but that is absolutely something that we can look at adding as we build out the purging section of this feature that'll be, several months out, and add some kind of flag on the report that has a time frame of when it will be expiring. We'll look at that as we get closer and continue working with everyone as we work on those specific things. So, how will this impact our client's ability to choose a report and reorder another background check for the same applicant and the same or different product? So when a report is archived in the system, all that does is lock it from the CRA being able to edit the results, and it creates that external PDF version as well in that external server if you've set it up to do that. So for the client, there's actually going to be no change at all. They're not going to notice that anything's happened because they can't edit those results anyways. They'll still be able to reorder things. They'll still be able to search for reports. They'll still be able to view them. Everything like that will be exactly the same up until that purge time frame. And then if you've set it so that after 5 years that that information disappears, then everything will completely disappear from the system. And we won't have an access to that anymore to be able to get it to you, you know, it's just, that's up to you. If you need to save that externally, then you can do that. So that is that question. A couple more that were submitted in the chat here is, can you or Scott address how to handle a dispute on an archived report? So again, archiving is, it'll still be in the system. If it's after that time frame, then it'll be completely deleted from the system. So, you know, if you get a dispute for a report after 5 years, that's part of what Scott was talking about, where like this protects you in that way because you don't have that information anymore. But, and you know, there are limitations on what the time frame is for when they can sue you on that. If it's within that time frame and it's still in the system, then nothing will change. You'll still have all of that data accessible, so there wouldn't be any impact to that. Somebody mentioned they get litigation hold for specific clients. Please consider adding this feature. That is something that we'll make note of. We'll look into that and do some more research to see if this is something that is necessary for more people. I'm not sure that archiving, purging, expiring reports when we have received a document retention request from a court could be considered compliant with the retention request. Yeah, absolutely. That is why we have that litigation hold, so that if you've received any retention requests, then it will freeze any of this from happening, so that across the entire CRA, so that it will not be exporting those, it will not be doing any of that stuff. And that way you can make sure that you are preserving all data exactly from the time that you get that request. All right, I'm going to just confirm that there aren't any other questions that have been submitted. Bartender Adam, do you guys have any other comments? Do you want to jump in on any of this and give any other comments about this? Sounds like
anything to say at the moment.
Kayla, I had a couple of questions earlier on, and you did a good job. I think I forgot them along the way.
Okay, we got one more question in the survey. What will happen to the application, authorization, and questionnaire? Adam, so authorizations are all stored as attachments. So each attachment to a report will get saved as a separate PDF and will be stored with the report, but its own file so that you can have those different things as needed. I'm not sure about the questionnaire. I'm assuming that you're talking about like in a quick app, what they were displayed. And I don't think that we are saving that currently. Do you have any other?
On the quick app questionnaire, we're talking about a quick app. The quick app documentation is saved as an attachment. So it would get caught in that same attachment process, but I think you'd have to know exactly which one should
that is true.
Yeah, those should all be saved with the attachments as well. And each attachment, I guess we should point out, Taylor, the attachments actually get saved in a zip. So all your attachments are zipped together, but they are saved individually. So if later you wanted to supply somebody with just the just one of the attachments and not the others, you can still do that. Just to clarify that they're not all saved as one big PDF with all your attachments.
Yep. So somebody mentioned they couldn't hear Adam as well as sound was a little bit fuzzier. So that will be saved. It will be another additional file. And all of those files will be individual files for each authorization, attachment, different things, and then they will be zipped together in one file, or in one folder, so that you can download those, manage them together. But then you can easily, just refer to one document. You don't have one massive document that may have stuff that you don't want to share externally with other things. So somebody else, I don't know the question to this one, so Adam, you might, or the answer to this one, so you might be able to jump in as well. I assume that the link sent to an ATS game integration will no longer work after the report has been archived. So after it's been archived, the links still work in terms of viewing things because everything is still accessible in the system. It's just after, it's reach that 5-year time frame or whatever time frame you set, then when we delete the information completely, then yes, it will no longer work. So yes, so if we don't do anything, when will files be purged? 4 years. If you don't do anything, then the time frame will be 5 years when data will be purged. And that's the maximum time frame that is set. You can change it to be shorter. And that setting, like the purging will not actually happen probably for several months. We will be, rolling out these first couple stages, making sure archiving works really well, working with everyone on that to make sure that they're trained, everyone can work with that. And then we'll roll out the settings, much later once everything's solid. And then after we've rolled out those settings, we'll wait a long time and then we will begin purging. And we'll be giving you guys lots more notice and training throughout this process. Yeah, if you do nothing, then eventually anything older than 5 years will begin disappearing. All right, it looks like that is all of our questions. We're at 1:05, so I think
and just
we're...
as a reminder, anybody who's unsure what's going on in the beginning can always put themselves on lit hold, and that would stop everything.
Yep. All right, well, thanks everyone for joining. We know these are big changes. It can be really overwhelming. We are, trying to be as slow as possible in this rollout. We're giving you lots of information as far in advance as possible. That can make it a little bit confusing because you can't see and touch things, but our goal is to, give you that education and the tools up front so that when these different steps come, then it's familiar and you can process it a little bit better. You can ask more questions. And we are committed to working through this process with you guys. We're not going to, skip through any of this without getting buy-in from people. We want to make sure that you guys are completely comfortable with this process. We can't promise that everyone will be perfectly happy with everything since different CRAs have different needs, but we are working on talking to as many of you as possible, gathering feedback and finding the solutions that work best for everyone, and at the very least making sure everyone has a complete understanding of how everything is working. And we will be continuing to talk to you guys over the next several months as we slowly roll this out. One last question was the user group scheduled for? I don't know the specific dates, but I believe it's sometime in May, the 20-somethings. But we can follow up with that after. So yeah, thanks everybody. Thanks Barton. Thanks Natalie. Thanks Scott. Especially, we'll be making the recording of this and the slides available sometime next week for those who weren't able to participate or who just want to review it. So thanks everyone. Have a great rest of your day.